Okay, we move on to the types of domicile. Basically, there are three types of domicile, i.e. domicile of origin, domicile of choice, and domicile of dependency. For the first type of domicile, i.e. domicile of origin, okay, everyone has a domicile of origin. He obtains this domicile at birth and in general situations carries it through his lifetime. It is suspended, this domicile of origin is suspended when he acquires a domicile of choice, but it can be revived upon the relinquishment of the domicile of choice. A person's domicile of origin follows that of his father if in the case of a legitimate child, or for illegitimate children, they will follow their mother's domicile. Okay, the second one is domicile of choice. Any person may acquire a domicile of choice provided he is an adult, meaning that he attains 18 years old according to Section 2 of the Age of Majority Act 1971. For female, the acquisition of domicile of choice is possible if he is an adult and unmarried. When a domicile of choice is obtained, the domicile of origin would be held in abeyance until the abandonment of the domicile of choice. We go to the requirements to establish domicile of choice. The objective requirement is maybe residence and voluntary. The subjective one is intention to reside at the place permanently. The burden of proof is on the person who asserts that he has obtained the domicile of choice. The change of abode or residence must be voluntary and not due to some compulsion. For example, due to duties, responsibilities, absconding from creditors, respite from poor weather, or for health purposes. Okay, the case to be referred to is Udni and Udni. The court held that selling off the house and its furniture indicates Udni's intention to terminate the domicile of choice. As a result, the law applicable to him is his domicile of origin. Now we go to Shaikh Abdul Latif and Shaikh Elias Baks. The deceased had a domicile of origin in Hong Kong. He moved from Hong Kong to Singapore and subsequently to Kuala Lumpur, where he lived for 19 years until his death. As his place of residence. Since he has no other house either in Hong Kong or anywhere else and had never returned to Hong Kong and his two Chinese wives, and he also embraced Islam and never visited China. The court held that he had acquired the domicile of choice in Selangor. The next case is Kanmani and Sundram Pillai. The respondent husband had nominated Kuala Lumpur as the place of payment under his insurance policies and intended his children to be educated in Malaya and had no intention of taking them with him to Ceylon. He was closely associated with a temple in Sentul and had expressed an intention to devote his life to it. However, he had not attempted to secure a permanent dwelling in The court held that his domicile is and the petition domicile is that of husband. That's Ceylon. Next, Justice Yoh Lun Gui. Petitioner was still a doesn't matter that she may be living separately from her husband. Only a decree of divorce will release her from this dependency. However, in England, the Domicile and Matrimonial Proceedings Act 1973 enables a wife to hold on to her own domicile without taking on the domicile of her husband upon marriage. In Malaysia, however, the position is still the same as in common law, meaning that the wife will follow her husband's domicile. The case to be referred to is Ang Gek Chu and Wong Tiu Yong. The petitioner was legally married to the respondent on 4th June 1987 at the National Registration Department in Malacca until July 1996. The petitioner, a Singapore citizen, resides in Singapore, which is her original place of domicile. The petitioner and the respondent went through chaotic time and had attempted to settle their differences 3 times before a marriage tribunal, but without success. The issue now is whether the petitioner was domiciled in Malaysia. In relation to the place of domicile of the respondent, no problem was posed for the court, as not only was he presumed to be domiciled in Malaysia by virtue of his Malaysian citizenship, but also due to the fact that he was at present living in Malaysia. As regards to the domicile of the petitioner, originally she was domiciled in Singapore, but according to the law of domicile applicable in Malaysia, her domicile changed to Malaysia upon her marriage to her Malaysian husband. The petitioner was, upon her marriage, domiciled in Malaysia. Therefore, the High Court of Malaya has the jurisdiction to hear the case, although the petitioner was in Singapore when the petition was made. Okay, now move on to the test to determine domicile. Basically, we also have 2 tests. The first one is dual domicile test. The capacity to marry raises an issue of status of which is most properly to be referred to as a matter of public concern to the country to which the spouse belong at the time of marriage, meaning that both of the parties have the capacity to marry under the law of domicile. In the case of lacking of capacity, the marriage will be held void. We are referring to the case of Maria Huberdina Hertog. Okay, the court held that the marriage was invalid because Maria's domicile was in Netherlands, followed her father's domicile. Under the Dutch laws, the minimum age of marriage for girl was 18. The English law applicable in Singapore recognized the marriage laws of the subject's country of domicile. Maria at that time was underage, therefore the marriage was void. However, in Maria Huberdina Hertog, this exception could not be established because both of them, the husband Mansur Adabi and Maria, were not domiciled in Singapore. The next case is Sotomayor and De Barros. The marriage was between the cousins and was solemnized in England. The domicile of origin of the husband is in England and the wife is from Portugal. Under the Portugal law, marriage between the cousins are prohibited. The court held for this case, applying the exception to the dual domicile principle, the marriage was held valid. We go to Martin and Umi Kalsum's case. Martin was an Englishman and Umi Kalsum was a Muslim girl. They contracted their marriage under the Christian marriage ordinance in Selangor. They have lived separately for 10 years and the petitioner asked the court to declare that the marriage was void as the respondent was a Muslim and by his personal law she was incapable of marrying him. The court held that, applying the exception to the dual domicile test and held that the marriage was valid. The second test is intended matrimonial home test. It involves the application of the law of only one legal system. The law applicable is the law of the place in which the parties intended to set up the matrimonial home. In the case of Radwan and Radwan, Okay, the facts of the case. In 1951, the husband, who was domiciled in Egypt, married his first wife in Egypt in a ceremony in polygamous form. In 1952, he married his second wife, who was domiciled in England, in the Egyptian Consulate General in Paris. This ceremony was again in polygamous form, and the couple established their matrimonial home in Egypt. In 1953, the husband divorced his first wife, and in 1956, he and his second wife went to England and acquired a domicile there. There were 8 children of this marriage. In 1970, the husband purported to divorce his wife by talaq divorce in the Egyptian Consulate General in London, and the wife petitioned in English court for divorce. The court held, although the wife's domicile of origin was in England, the marriage was valid since her capacity to enter into a polygamous union was governed by the law of Egypt, where before their marriage, the parties had decided to set up their matrimonial residence and where polygamy was practiced. Okay, for the conclusion, in Malaysia, the courts are still adopting the old concept of domicile. Thus, it is submitted that the requirement of domicile in a petition for divorce under sections 18 and 49 of the LRA is unfair to both parties to the marriage. Accordingly, section 49 should be amended, or maybe alternatively introduce a new section in the LRA to enable the wives to have domiciles of their own. Thank you.